as well as Fargo, Wachovia, but it says their dilemma is they hate to love niggers and love to hate niggers.
Hello, welcome to another edition of the Courtroom of Public Opinion. My name is John Singletary, and today our topic is recusal. Oftentimes, it comes a point in a judicial setting in which a judge must recuse himself, whether it be because he knows someone in the case, because there's an appearance of him being a non-neutral jurist, a hint of impropriety, but at some point, if requested and it looks like there could be favoritism, a judge should recuse himself. Unfortunately, all too often that does not happen. Today I'm going to tell you about two cases in which I felt that a judge should recuse themselves. I'm in Charleston, South Carolina. First case was for Singletary versus North Charleston, in which it was an appeal from a zoning decision that went to a circuit judge, Judge Roger Young. Now, Judge Roger Young started off the 15-minute hearing that was held in between another case in which he was trying a case that dealt with murder. Anyway, he comes over for 15 minutes and says, we're going to give each side 5 minutes, and I got to get back to this other case because I'm going to charge the jury. Now, it was requested that he recuse himself from the case. In coming to the courtroom that was next to his, even though all civil cases, by virtue of agreement, the clerk of courts decided they would round robin cases from Dorchester County, Berkeley County, Charleston County. All cases no civil cases were in Charleston County. However, he wanted me to show up in the courtroom next to the courtroom that he was having this other trial at, that the clerk of the scheduler had no idea we should be there. In fact, she said that all cases were in another county. At any rate, get into the courtroom and find that Brady Hare, who was a long-term friend of his from Dixie Youth Baseball, and you can look up Dixie Youth Baseball League and see what type of issues are involved when it comes to Dixie Youth and racial animosity. However, he also was at R.B. Stahl High School with none other than Brady Hare, even though he claimed that he knew no one who was involved in the case at North Charleston. This is what came out of his own mouth. Now, Brady Hare was in the courtroom talking to him, passing documents to him prior to the little hearing that we had. He also used to work for the city of North Charleston. He worked not only as a judge, but also for the city of North Charleston, who was the defendant. So he's working for the defendant as a judge, and he also worked for the defendant as a city attorney. Brady Hare, his long-term friend, was the one who replaced him acting now as the city attorney. In addition to that, the mayor was named in the lawsuit, Mayor Keith Sonny, and he too knew Judge Roger Young. Well, how do you know he knew Judge Roger Young? Just because he's in the city and because Judge Roger Young was a judge there and because he was also the city attorney doesn't mean that he knew Judge Roger Young. Well, when you take a look at the Civil Justice Reform Act of 1990, one of the things that it requires is a questionnaire. That questionnaire a judge fills out when he makes application to become a judge. And there's normally some people on that form or application who recommend him to be a judge. Now, Brady Hare, the legal department is headed by Brady Hare. The legal department is a named defendant. So is Mayor Keith Sonny a named defendant. When you look at that questionnaire, who appears on the questionnaire? Mayor Keith Sonny, Brady Hare, as one of the people that are recommending Judge Roger Young to be a judge. Yet he claims out of his own mouth that he knows no one in the city of North Charleston. Now, mind you, Judge Seagars Andrews just recently got removed from the bench, stating that she was no longer fit to handle her duties to administer justice. Here it is, Judge Roger Young is doing something far worse, in that he is sitting on a case for his former employer. And he says that when he is asked to recuse himself, that he refuses to recuse himself. In addition, his former employer, the city of North Charleston, asked him whether or not he's going to listen to any of the merits of the case. And he says absolutely not. He's not going to listen to any of the merits of the case at this short hearing. He's got to get back to charge the jury. We only got 5 minutes each, so we're going to discuss the merits at a later date. The later date never comes. Not only does Judge Roger Young make an instant decision the next day in favor of the city of North Charleston, but his answer to why he didn't recuse himself was because he said he forgot he used to work for the city. He forgot. He, a judge, forgot he used to work for the city in several capacities, the same city that he grew up in, the same city where his friend Brady Hare and two people, Brady Hare and Keith Summey, who recommended him on his application to be a judge, he forgot about those relationships. Oh, it gets worse. It goes on and on and on. But how can you as a judge forget where you used to work? How could you forget the fact that fundamental fairness, due process, equal protection, and the right to be heard hinges on whether or not you give a fair hearing? Now, there are many other cases, at least 15 cases that I found in the state court where City of North Charleston has come before him, and in every single case that I found, every single case, he's always ruled in their favor. Now, that's bad. But the awful part is that once this information is turned over to the South Carolina Misconduct and Review Board, they come back with an answer that simply because someone is not pleased with the decision of the judge, they will not get involved. And so as a result, all of this information is brought before them and they refuse to get involved for Judge Roger Young, who's refused to recuse himself, and for someone who he worked for. He's ruled in their favor many times, his former employer, his best friend, or one of his closest friends from childhood, Dixie Youth Baseball. And when you take a look at the history of Dixie Youth Baseball, you will see that it was closely connected with the Cannon Street Boys and the World Series, and Danny Jones wanting to have a situation where no black boys would be able to play with the white kids. And he and Brady Hare was in that first set of group of boys that came through. And so it's been a part of their history to stay segregated, and in this case, to deny justice, due process, equal protection, the right to be heard. And in addition, he takes paperwork, documents from the city of North Charleston that during that hearing they refused to allow me to see. Not till several days later, but of course, like I said earlier, the decision had already been made that not only to deny my right and request and my demand for a jury trial, but he rules in their favor, and the South Carolina Misconduct and Review Board, even though they had just previously got rid of Judge Seagars Andrews, says that it's okay for Judge Roger Young to do that. Now, the thing that comes to mind immediately is Judge Roger B. Taney. Judge Taney said that a black man has no rights that a white man has to respect. Whether it's Roger Taney or Roger Young, the end result in this case happens to be the same thing, that the right to due process and equal protection, the right to be heard, the right to fundamental fairness has been denied. And it is supported by the Misconduct and Review Board of South Carolina. Certainly the Misconduct and Review Board has to take a better stance when citizens' rights to due process, equal protection are violated. Judge Roger Young has to know. He has to know that not only is it wrong, but that he'll be exposed for doing such things. Now, this is just a short video to kind of tell you about what has happened. Eventually, I'm going to take the documents and I'll put the documents on the screen so you can actually see with your own eyes the documents associated with this grave injustice. Moving right along, it goes on to the master in equity. The master in equity is none other than Judge Mikhail Scarborough, who just recently was asked to recuse himself in a case. And what he did was he ruled in favor of the opposing litigant, gave them everything they wanted, and then at the end recused himself after the dirty work has been done. Now, here's where it gets worse. It gets worse when you find that he comes in to give what is called a hearing on the record, but he never sits down in the chair. He never lets either litigant say anything. He basically comes in, reads everything off of a document that says that, I'm going to let them move forward with everything that they want. I'm going to deny your claims, then I'm going to recuse myself. Well, if you knew you should recuse yourself, you should have done it at the beginning, not at the end. It would seem fairer to do it and say, hey, listen, I should not be on the case. Not I'm going to make a decision, then I'm going to recuse myself at the end when it's a moot point. It gets worse when we then go to the next phase of the process to find that on the second floor he recuses himself, and in the very same building less than 30 minutes later, we're on the third floor in the second phase of the same case. And here it is, Judge Mikhail Scarborough shows up again. He shows up as the administering judge on the very same issue. I guess the recusal was only good for the second floor of the Charleston County building, not for the third floor. Now, as I stated earlier, all judges have to go through this questionnaire dealing with the fitness of the judge as well as a lot of other things. And there's some interesting names that are on that, particularly when you look at some of the cases that have been that he recused himself from, and who the special referee happened to be. Somebody who recommended him to be a judge. Well, all I'm saying here is that the Misconduct and Review Board in South Carolina needs to take a closer look when a judge is asked to recuse himself, the process that's being used to do that. The law says if there's a hint of impropriety, that he should. But when you have these kinds of underhanded skullduggery tactics going on, and then once they uncovered, then the Misconduct and Review Board takes the stand of tacit endorsement, where they actually will turn a blind eye, deaf ear to flagrant and blatant disregards of the law, then where do you go? How does that help the profession in terms of people looking at the South Carolina judicial system? The only thing that you can do is you have to ask the Department of Justice to get involved. Now, we've had martial law in South Carolina before. We know that the Compromise of 1877 ended that with another underhanded move, but it may be required that the Department of Justice take a look at judicial martial law, because we are being denied the right to jury trials wholesale. We are being denied the right to fundamental fairness, the right to due process, the right to equal protection, and these types of things are vexing, and they are contrary to the Constitution. Repugnant to the United States Constitution. So what we're doing is we're, at the Judicial Freedom Riders, we're asking you to join us. July of this year, July 4th, Independence Day, 2014, we've started a campaign. We want to get 1 million members in 1 year, and what we will do is we will begin to uncover and fight this type of corruption not only in South Carolina but other states, simply because this precious right to fundamental fairness, to have them adhere to the rule of law, is very important. And without it, justice cannot and will not be served. Now, I guess we'll end it here. We'll end it here because we want the videos to be short. We want the videos to give you enough information such that you will know that our purpose is important and that it is something that you need to be involved in. So stay tuned. Next session of the Judicial Freedom Riders CPO, Courtroom of Public Opinion, will have a very interesting subject matter that deals with the judicial system and reports that judges are altering and sending to the Judicial Conference. Stay tuned. See you next time. Bye-bye.